Good evening. Welcome to the theater. Boy, welcome back to the theater. I have not stood in a group this large or a theater this big in a long time, and it's great to be here and to see all of your faces. I am so very much looking forward to this show tonight and us all being here together. My name is Ian Kelley. I am an adjunct professor of constitutional law, John F. Kennedy University, right up the road in Pleasant Hill, and also at San Francisco Law School. And I have been lecturing and teaching on constitutional law and civil and criminal procedure for the last 15 or 18 years or so. And when they wanted to do a collaboration, the solo opera company, with an academic institution, JFK said, oh, well, you know, Professor Kelley, the students find him very entertaining. Maybe he should come and give a little talk on the Constitution. This was mid-2019. I said, well, that sounds great. I've got it all queued up. I know exactly what I'm going to talk about. The best laid plans, and here we are sometime later. But that's me. This talk tonight is going to be a short talk in 3 parts, pretty much as follows. Part 1, a brief history of the Constitution. Part 2, everything I need to know I learned in law school. Part 3, some thoughts about the future. In teaching constitutional law, one of the most common questions that people ask me is, what's up with Justices Scalia and Ginsburg? I think prior to 10 or 15 years ago, the depth of their friendship was not well known. Jeffrey Toobin, some point, maybe 20 years ago, published his book, The Nine, which was an in-depth look at the Supreme Court. And that started to bring it to the fore and then trickled its way into public consciousness. And I think especially in the last few years, people have become fascinated by this friendship, understanding it as they do from 2 people so far ideologically opposed. And I'm asked, and have been asked many times, to try to unpack this, and I usually lean on sort of superficialities, or I say, well, the truth is what it means to be liberal and conservative in the context of jurisprudence is very different than what it means to be liberal and conservative in sort of public American discourse, political life here in America, and so that explains some of it. It doesn't explain all of it, and the truth is I'm not going to explain all of it as I sit here now, in no small part because I have not actually seen this show, and I'm reluctant to step on their lines or reveal any of their secrets. So I don't know what their explanation is going to be and what they're going to say, so I thought it best that I frame it a little bit with an understanding of what Justices Scalia and Ginsburg are working with. And although I've been deeply gratified to have a few students come up and talk to me before the show, and I know some of y'all are out there in the audience, my assumption is that most of the folks I'm talking to are enthusiasts of the Constitution rather than professionals or people who spend all their time with it, which is good for me because it's going to make it harder for you to know when I'm getting it right and when I'm getting it wrong. To the degree you find that I've gotten it right or wrong in a way that is appealing or aggravating to you, I think there's a link to where you can reach me in the program. By all means, email me and tell me what I didn't get right. That's a big part of how I learn, which is a little part of what I'm going to talk about. So, a brief history of the Constitution. We all know pieces of this story, right? It started with the Declaration of Independence. It started with that great sentence. We hold these truths to be self-evident, that all men are endowed by their Creator with certain unalienable rights, among them life, liberty, and the pursuit of happiness. It's probably the most well-known sentence in American political life. It's not without its problems, as is obvious enough just to say it out loud. And that's sort of where it started. That sentence, published in those broadsides between July 2nd, July 4th, 1776, in the Declaration of Independence, kicked off the revolution. And we fought this war, and we fought this war for, give or take, 5 years. Hostilities, the revolution probably mostly ended with Cornwallis's surrender at Yorktown in 1781. We didn't sign a peace treaty for another couple of years, but as a functional matter, the revolution ended in 1781, and now we were the United States. And what were the United States in 1781? We didn't have a constitution. And if you had asked anyone living in the United States. They would not have said, well, I'm an American. That was not the manner in which they thought of themselves as sort of the polity in the United States. They'd have said, well, I'm a Virginian, or I'm a New Yorker, or what have you. We did not really have the union that we modernly think of when we think of the United States. We had a confederation, and that's what we worked under. We worked under the Articles of Confederation, which were ratified there in 1781 and were the governing document that drove America. And it made us a loose-knit, unified band of states. There was a Congress, but there was no president, there was no judiciary, and they allowed the states to work together to some common goals, but were frustrated in sort of larger common goals. It's largely viewed, and it's a bit of a simplification, but it's largely viewed that the Articles of Confederation failed because they did not give Congress the power to tax, to raise money, to pay off revolutionary debt, and to fund the United States. And they did not guard against the kind of trade disputes between the different states that kept goods from flowing around and making us sort of one unified whole working together. And so recognizing that, delegates from the several states gathered there in Philadelphia in June of 1787, ostensibly to revise the Articles of Confederation, but really, the minds of James Madison, the minds of Alexander Hamilton, to write something new, to come up with a whole new thing. And they had kind of a plot to do this thing once they got everyone there. It's been a lucky few years to teach this stuff because Hamilton happened, so now people have a lot more background than they had before, so we know some of these players. James Madison, at the time of the Constitutional Convention, was 36 years old. These were young men. Hamilton was 30 years old. And they were largely the mastermind architects. I mean, Jefferson was there. He'd written the Declaration of Independence in large part, and he had a lot to do with it. But in terms of this notion that what we're going to do is we're going to get together. No one, these delegates don't know it, but what we're really going to do is completely throw out the Articles of Confederation. We're going to do a whole new thing. That was largely something that a few of them thought together, Madison and Hamilton right at the center of them, and sort of plotted to draw people in as the delegations arose from the several states. They said, well, we need someone important to preside over this, right? We got to give this some gravitas, some legitimacy. Who do we get? Let's get General Washington. Hamilton, you know him. Let's get General Washington. And so George Washington presided over the Constitutional Convention. They were all pretty young men, and so they got the oldest men they had around there in American political life. They got Ben Franklin, who was living in Philadelphia. He was 81 years old, carried in a sedan, one of those chairs where 4 people are holding the corners of it, carrying him in each day into the Constitutional Convention. And in that long, hot summer of 1787, they wrote what would become the U.S. Constitution. Sent it out to the several states, and it was ratified a year later in 1788. Now, the great offering of the Constitution to sort of Western political thought was this concept. We'd already moved away a little bit from this notion that all the power flowed from God, right? We got into this notion that, well, maybe the power flows from the people, the consent of the governed. We're already walking our way down that road. And the Constitution introduced another notion still. It was the notion that maybe there can be more than one source of power. Maybe there can be a source of power that sort of flows naturally from the states, which felt like the natural organizing bodies. These were where people were from. I'm a Virginian, I'm a New Yorker. Maybe there's a source of power that flows from the states, and maybe we can join together and decide that we're going to give some piece of that power to some other body, to some other sovereign. And that sovereign will also have that power, because as the governed, we can consent to have more than one sovereign. And so there was this concept of dual sovereignty called federalism. And this federalism was the great contribution of the Constitution to Western thought. And so it put in place right off a big issue. It put in place right off a big tension. And the tension was, well, so what power belongs to the states and what power belongs to the federal government? And they had a pretty ready answer. They said, well, the federal government is a limited one. The only powers the federal government has are the powers we're going to give to it. Every other power not explicitly listed in the Constitution will be reserved to the states. It was an all right answer. It worked as well or as poorly as it did, and it continues to work as well or as poorly as it does. The point of these last few minutes I've been talking to you here is that there's really nothing new under the sun. This tension between what power ought be held by the states and what power ought be held by the federal government has been there from the very beginning. It is, in fact, baked into the document itself. 'Twas ever thus. That was the main tension. There's a simmering background problem suggested by having something like a constitution, which is, well, how do we go about interpreting it? The Constitution did not come with annotations, and it did not come with a guidebook. We understood it to have been written in English by people who were largely descended from the common law tradition, the judge-made law tradition of England. And that much could be said. But beyond that, the Constitution doesn't tell us how we're supposed to interpret it. And the Constitution begs for interpretation because it's not a law, it's not a statute, it's not a code, it's a constitution, and it speaks in broad terms, like liberty, like due process. Broad terms that demand a measure of interpretation. And this has always been a constitutional problem. At the beginning, there were very different sorts of interpretive problems. Who's supposed to interpret the Constitution? Well, okay, now we've got these three branches. We've got the Congress, we've got Article 3, we've got the judges, this whole federal judiciary, we've got this chief executive, we've got a president. Who among these are supposed to interpret the Constitution, or do they all interpret it, and does it matter, is anyone any more authoritative than the next? And in a little bit of a sleight of hand that took place some 15 years later in a case called Marbury v. Madison, and a couple of heads are nodding, people who've been to law school or read about this sort of thing, Justice John Marshall put forth this notion that, well, really it's the judiciary that should be interpreting the Constitution, because isn't that what we do? We're judges. We interpret. That's what we do. And he said it in sort of a gentle enough way that everyone just sort of went along with it, and then that became the rule. It's not written in the Constitution. That just became the rule, that it's the courts that do the interpretation. And they worked along like that for a while, and then other interpretive questions started to appear. How literally, how narrowly or broadly do you interpret the Constitution? You know, the federal government has given these very specific powers to start a post office or to mint coin. Okay, so does that mean the federal government also has the power to build roads that the post trucks can ride on or the post carriages can ride on? Because the government has the power to mint coin, does that mean that the federal government also has the power to start a bank? I mean, we all agree that the federal government can only do the things it says explicitly in the Constitution they can do. Doesn't say anything about banks, doesn't say anything about roads. So how is this going to work? Well, there's this one provision in there in Article 2 under the powers of Congress says, well, Congress shall also have the power to do all those things that are necessary and proper for the foregoing. All right. The problem is that's not real helpful right there. Right? And so this was another interpretive problem. How narrowly or broadly do we consider this sort of thing? And that carried us all the way from that first case in 1803 into McCulloch v. Maryland in 1819, the next really great constitutional case, where they said, well, you know, necessary means those things that are reasonably necessary, which only helped a certain amount. And I say by all of this that we've always had interpretive problems. But the sorts of interpretive problems that we had at the beginning are different than the sorts of interpretive problems that we have now. And that was the end of interpretation for a little while. It was the 1820s and the 1830s. Discord between the states and the federal government was brewing. That long simmering problem baked into the Constitution was bubbling up to the surface as new states were admitted to the Union, and then the war came. And then we spent a whole bunch of time fighting about, ultimately, who had the final say in certain matters, both interpretively and in the rights of the people under the Constitution. the state or the federal government. And then interpretation took a back seat for a long time. And it took a back seat largely until the 20th century. And I can tell you, there's really no more exciting time to be a constitutionalist than right about now. Because constitutional interpretation is alive and well and is vigorously debated in a way that it has never been. The truth is, we have to really squint a little bit to look backwards and find very certain views of interpretation as contrary to others, because there just was not that much debate about how the Constitution was to be interpreted. There were different interpretations, of course. Every justice had a different take on it. But it wasn't a really refined system. We didn't have what we have today, which are two broad camps. Two broad camps on the notion of constitutional interpretation. One that I'm going to call very broadly originalism, and one that I'm going to call even more broadly the view of the living Constitution. So, originalism. Originalism is the theory of original meaning, the notion that we interpret the Constitution according to what reasonable people in 1788 would have understood the Constitution to mean. This was Justice Scalia's view. This is a comparatively new view, which that does not make it right, wrong, indifferent. There's nothing in particular to observe about that other than the fact that originalism, for calling itself originalism, is in fact the newer of the constitutional interpretive views. It was really first proposed academically in the 1970s. Judge Robert Bork, famous for other reasons, wrote an extremely influential academic article on the notion of originalism. And really, originalism reached the Supreme Court with Justice Scalia's appointment in 1986. That's where it really found a foothold in American jurisprudence. Though to say that, the notions behind originalism are not new ones. Later in life, James Madison himself, he said, I entirely concur, my Madison voice, I entirely concur in the propriety of resorting to the sense in which the Constitution was accepted and ratified by the nation. In that sense alone, it is the legitimate Constitution. People who like to argue about interpretation like to dig deep and find things that the founders say in order to bolster their argument one way or the other, and this is one of those cases. And so we might think of Madison as something of an originalist. Observations and criticisms. What's good about originalism? Well, it's appealing. It's extremely appealing in its analytic straightforwardness. We know what we're supposed to be doing. We know the body of information that we're supposed to be referencing in order to figure out what a given provision of the Constitution means. What's not good about originalism? Well, first and foremost, it binds us to the views of people who lived 250 years ago, who had very different notions of those burning questions, things like liberty, than we do today. Look, everything I'm saying here is necessarily very reductionist, right? These are I've got a dozen slides, and every one of them is a semester-long class unto itself. So if I'm getting a piece of it wrong, you know where to find me and tell me so. On the other side, I'm not sure which the sides are. On the other side, we have the living Constitution, the theory of evolving meaning. We interpret the Constitution by reference to our evolving standards of decency that mark the progress of a maturing society. Evolving standards of decency that mark the progress of maturing society. It was a 1958 case talking about the Eighth Amendment, talking about the question, what does it mean to prohibit punishments which are cruel and unusual? What do those terms mean? This view that we interpret according to an evolving meaning, this was Justice Ginsburg's view. And in this way, they were polar opposites at the core of their analytic approach to constitutional interpretation. Now, what can we say about this living constitutionalism? This was an older view. It developed in an academic sense in the early 1900s with Woodrow Wilson, who was an academic before he was president, Oliver Wendell Holmes, a justice of the time, but the notions of the living constitution were not new in the 1900s. Thomas Jefferson said, Jefferson voice, laws and institutions must go hand in hand with the progress of the human mind. As that becomes more developed, more enlightened, as new discoveries are made, new truths disclosed, institutions must advance also and keep pace with the times. What's good about living constitutionalism? Well, much of the Constitution requires moral interpretation, right? When we look at a term like liberty, the one to which we keep returning, it's not a question of what the word liberty means. It's a question of what sorts of liberties are entitled to constitutional protection. There's a good argument that an evolving view of things like civil liberties is necessary for the Constitution to work. The view has to continue to evolve. Otherwise, we do not protect the people not protected by the founders, and only protected, for that matter, by later amendments, if at all. Coming to mind, women, the descendants of slaves, people who aren't heterosexual. The Constitution does not otherwise protect these groups of people, but for an evolving sense of moral interpretation. That's what's good. What's not good about living constitutionalism? Well, it allows for a type of judicial interpretation that, some argue, does not impose principled limits on judges. It allows the court and courts to make policy rather than just interpret it. And so these are the basic poles of the debate that Justices Scalia and Ginsburg were coming to when they looked at the basic questions of American debate. What controls belong to the federal government and what to the states? What rights and interests should be protected by the term liberty? These are the interpretive places around which Justices Scalia and Ginsburg disagreed. But I want to say a bit about this disagreement. It's Supreme Court disagreement, even in this extraordinarily polarizing time, is not as much as is commonly supposed. And the reason we suppose it is because we look to the Supreme Court as sort of a stand-in for the larger culture war happening in America. In truth, the Supreme Court agrees unanimously in many more cases than it does not, and Justices Scalia and Ginsburg agree, give or take, about 70% of the time. The areas of disagreement are oftentimes hot-button issues to the, to people watching the news, to people not closely following the court, to looking at the half-dozen significant or sexy-seeming cases in any given term. In the other 120 cases, the court is much more in agreement than not, and just doing an ordinary sort of interpretive thing, whatever approach they happen to be taking. So, there's a brief history on the Constitution. Parts 2 and Part 3 are a lot quicker. Everything I need to know I learned in law school. I learned 3 things. Justices Scalia and Ginsburg learned a similar set of 3 things. Number 1, reasonable minds may disagree. Reasonable minds may disagree. Number 2, the goal of a conversation is not to win. The goal of a conversation is to learn something. And if you are lucky, to teach something. This is true even in the context of Supreme Court argument, where there are people assigned to either position in order to sort of vigorously carry one side of the debate. But still, what we're trying to do is persuade other people, and we persuade partially by listening to other people. And what this all adds up to is number 3, and this one's important. Recognize the difference between an enemy and a friend with whom you disagree. And so in 3 minutes' time, some thoughts about the future. Historian Heather Cox Richardson says this. She says, history doesn't repeat itself, but it sure rhymes. We're living history right now. It's a history of a bit of a dire sort. I didn't know what I wanted to say about this and how much I wanted to say about this. But I'd feel remiss not to observe that we're standing here 20 years from the defining political event of my own time, 20 years ago tomorrow. My family is here tonight, my kids are here tonight. I have a 19-year-old son, and for his entire life, 19 years, the United States has been at war for his entire life, except apparently for the last 10 days. We're masked and distant behind a public health crisis without an end in sight. The Earth has been heating up since the beginning of the 20th century. Last 7 years have been the warmest ever recorded. We are living in history, and a lot of us are on edge, and we're on edge for good reason. There is, I would suggest, a way forward. There's nothing broken. There's nothing broken that we couldn't fix with science, with ingenuity, with our will to fix it. What we need to find is that will, that sort of commonality of purpose. We need to find those places where we agree. A lot of people are pulled to a show like this, into a story like this, because what they're pulling for is how do we bridge that gap and find those places where we agree? History doesn't repeat, but it does rhyme. The Constitution is a good place to start. What is the purpose of government? What are we here for? Well, the preamble says this. It says, here's what we're here for. The goal of government is to establish justice, to provide for common defense, to promote the general welfare. Those goals gave rise to this tool, the Constitution, and that tool had a purpose, to form a more perfect union. When we say it like that, it seems so obvious. So how do we still have so much disagreement? I was thinking about this when I went to a family event last week, and it was the first one I've been to in a couple of years. And as is common with this sort of thing, I was thrown together with people whose politics are very different than mine, and found myself sitting around the family dinner table, getting into arguments with people. And what seemed to be happening is we were arguing about two different things. We couldn't agree on stuff because we were not working from the same set of facts. And this gives us an insight, I think, into why Justices Scalia and Ginsburg could disagree so profoundly but still be so close, and why many of us find ourselves in such deep disagreement with people who we otherwise feel close to. In America today, we are not working from a shared set of facts. We're all working from different information with different levels of accuracy. When a case comes to the Supreme Court, the facts are settled. They're bound into a book. They happened at the lower court levels. The light was green. The guy had the knife. Whatever it was, and there's no disputing what the facts were. There's only disputing what they mean. And so to close, I think a big part of being able to disagree respectfully, to have a conversation where we both learn and teach, is to start with some agreed upon facts. From there, we can work our way outwards to a discussion of values. What sort of country do we want to see for ourselves, for our children? How can our government accomplish this? Armed with shared facts, we can talk about the values. Working with different facts, we're stuck arguing about the facts themselves. These values-based discussions about the role of government, about how best to promote liberty, are not new. We've been talking about them as a nation since the founding. Justices Scalia and Ginsburg seem to stand out because there was between them, what they had between them seemed able to transcend their clear political differences. They were engaged in this work that we should all be tuned into, this work of building a more perfect union. Thanks for listening to these thoughts. Enjoy the show.